Judge. Would you please repeat your name for the record?
James Foley?
And Mr. Foley, I want to direct your attention to April the 17th, 2021. Were you at the location of Belleville and Ecorse?
Yes.
Is that in Van Buren Township?
Yes.
Is that in Wayne County?
Yes.
And Mr. Foley, did something occur at that location that brings you into court today?
Yes.
Could you take the court to the beginning of those events?
I mean, there was a, what I would call a fender bender.
Were you driving?
Yes.
Was there anyone else in your car?
Yes, my wife.
And what kind of car do you drive?
An F1, it's an F-150. My wife generally drives it, but I was driving it that day.
So you said there was a fender bender. Can you please describe that fender bender to the court?
I was behind a gray car. We both turned right onto Ecorse Road, headed westbound. The gray car made a, what I'll call a sharper right turn. I made a wider right turn because I was going to get in the left lane to do a Michigan turnaround. And then we contacted each other right front to left rear.
The right front of the gray car?
The right front of the F-150 to the left rear of the gray car. Then we continued through the turnaround.
Your car is the F-150. I'm sorry, I didn't mean, but your car is the F-150, correct?
Correct.
Okay.
Continued to the turnaround. We stopped. Then the car in front of me went around the turnaround and stopped at the red light at Belleville Road and Ecorse Road. So we were facing eastbound then. Put the truck in park, got out, walked up to the driver's side of the car, leaned down, asked him if he wanted to go, or asked whoever was in it, do you want to go to the police station? And at that point there, he had gotten out of the car with a gun in his hand, and I don't remember the exact verbiage, but it was either get the F back, I don't know you, or I don't know you, get the F back.
Okay, so we'll back up to when, so you had parked in the, you put your F-150 in park where?
We were in the left lane of Ecorse Road at Belleville Road, headed eastbound.
And was that in the lane to make a Michigan left?
No, we had already gone through that whole turnaround.
Okay.
And then the light at Belleville Road was red, so we were both stopped.
Okay. And that's when you got out of the vehicle?
Correct.
And what was your intention when you got out of the vehicle?
Objection relevance.
I'll move on, Judge. One moment here. Actually, Judge, may I respond to that objection?
Absolutely.
Yeah, Judge, the people would contend that it's relevant as to his intention when he approached the vehicle would certainly lend itself to any appearance when he approached the vehicle or just his state of mind as he approached the vehicle. The people would contend that that's relevant to the charge at hand.
His state of mind is not relevant, and if he wants to describe what his demeanor was as he was getting the vehicle, that's fine. But what he meant to do, it doesn't matter.
Objection sustained.
Okay. So, what was your demeanor as you approached the gray vehicle?
Just walking up to it to see if they wanted to go to the police station, making a police report or something. I could see the left tail light was broken, so there was damage on the car. And I knew the police station was only, maybe a mile away, if that. We were either going to the police station or waiting there. There wasn't anyone injured.
I understand. Now, Mr. Foley, you said he pointed a gun at you. How close was this individual to you when they pointed a gun at you?
Less than 5 feet.
Objection, mischaracterization of the testimony. He didn't say he pointed the gun at him.
I believe he said that.
He said he had a gun in his hand.
Okay. Did he point the gun at you?
Yes.
Okay, so when that individual pointed the gun at you, how far was that individual from you?
Less than 5 feet. I mean, I was at his left side and he got out the left front door of the vehicle.
And is that individual that pointed the gun at you in the courtroom or on the Zoom screen today?
He's in the courtroom.
Could you identify that person for a court and identify an article of clothing they're wearing?
Blue suit jacket.
See the defense counsel table?
Yes.
Your Honor, may the record reflect the witness has identified the defendant?
Yes, sir.
So, Mr. Foley, after the gun was pointed at you, what did you do next?
I went back to my truck and dialed 911.
And did you speak with police after that?
Yes, several policemen. I don't
Okay.
remember all of them.
And one moment, Judge. And Mr. Foley, when the firearm was pointed at you, how were you sure it was a gun?
I saw the barrel of it pointed at me. I've seen a gun before. I mean,
Are you familiar with guns?
vaguely, I mean, I know what a handgun looks like. I know what a rifle looks like, and it was a handgun.
Your Honor, I have no further questions for this witness at this time.
Thank you. Sir,
Good afternoon.
Okay, so if I understand you correctly, your F-150 struck this gray car that was in front of you,
Correct.
is that right? And your front right part of your F-150 hit the rear left part of this car
Correct.
as you were turning.
Well, I think I believe our turns were completed and now we were both headed straight on Ecorse Road westbound. I knew I was getting in the left turn lane and I'm assuming they were getting in the left turn lane because they came over and we hit each other.
And at that time, you didn't exchange any words out the window with the.
No, it was a chilly day. The windows were up. So, I mean, it wasn't like it was a warm spring day.
And it was the road was pretty busy at that time, correct?
I don't really remember how busy it was. I know there was, I started out heading southbound in the left lane. Somewhere around Van Born, there was a Mustang in the right lane. He got over in front of me and then I got over in the right lane because I knew I was making a right turn. But yeah, I don't remember there being a lot of traffic, but there may have been. I really don't recall that.
And so walk me through after you strike the vehicle, how it is you come to a stop or how far that is from where you are completing your turn.
Well, we actually both stopped in the left-hand turnaround lane for, a few seconds. I thought we were going to exchange information there. But then the gray car continued through the turnaround. And as we came through the turnaround, the light at Belleville Road had turned red. So that's where we both ended up stopping. So the total distance, a few hundred yards.
So you're heading, let me make sure I understand you. You're heading westbound on Belleville when,
West on
South.
Ecorse.
west on Ecorse, sorry.
Correct.
When the
Collision
collision
occurred.
occurred. You then stop momentarily,
Yes,
and then the gray car then proceeds through the turnaround. You follow the gray car,
correct.
and then you stop in the left lane on eastbound Ecorse at Belleville.
Correct.
Okay. So, when the cars both stop, you exit the vehicle, right?
Yes.
And you don't say anything you don't shout anything toward the car. Right?
No.
You don't say anything at all. You begin to approach the car.
Right.
And I think you said that it was a little unclear from your direct testimony. At what point did a person get out of the car as you were approaching?
I was at the car already and I leaned down. I don't know if the window was up or down at that point. And I said, "Do you want to go to the police station?" So I'd already said that and then he got out of the car, maybe a split second later or a couple of seconds later than that.
And so you don't remember if the window was down or not when you said that?
I do not.
So you walk up to the car, you say something to the effect about going to the police station. Where are you in relation to the driver's door? Are you at the rear left part of the car? Are you does the door hit you as you open it?
Not close enough to where the door is going to hit me, like behind, the driver's door was obviously able to open without hitting me because he got out. So I was, maybe a half a foot back from that. Not very far back.
And as you were approaching this driver's side of the car, you had your hands in your pockets.
I might have, I do remember I was wearing an olive green spring jacket. I don't remember the exact weather, but I might have had my hands in my pocket because it was windy or cold or whatever.
Well, you did speak with the police, I think, as you indicated, shortly after this incident occurred, correct?
Yes.
And you said you don't remember whether or not you had your hands in your pockets. You said you might have.
Yeah, I might have. I don't remember.
When you spoke with the police, it was closer in time to the incident than it was today.
Right.
Obviously, this was within moments of this happening. Is that correct?
What's that?
It was within moments of this happening.
Yes.
And your memory at the time of what occurred then is clearer than it is now.
Yeah, I mean, well, even my memory then was foggy because I would have never expected someone to pull a gun on me walking up to a car.
Right. But I mean, for instance, you probably knew V Course was busy that day when you talked to the police versus sitting here.
Yeah,
So-
it wasn't busy. I'm trying to remember if it was a Saturday or Sunday afternoon. I think it was a weekend afternoon, so it wasn't busy like it would be on a work day.
You told the police that when you approached the car, you had your hands in your pockets like this, didn't you?
I may have. I really don't remember. I didn't read my statement.
I'm going to show you what's been provided by the prosecution as Defense Exhibit A for the purposes of this hearing. This is a body on camera of Officer McCarthy. Timestamp 15. 32 on 129. Okay. So, Mr. Manford,
Absolutely.
Mr. Foley, I'm showing you what I've marked as Defense Exhibit A for the purposes of identification. I haven't started this yet,
All right.
but we can see from this that this is a video, correct?
Yes.
And in this video depicts both you and your wife, is that correct?
Yes.
Okay. In that green jacket you mentioned, you see yourself in that right now, right?
I think, yep, that's it.
I'm going to play a couple seconds of this here, just so you can hear.
This incident happened when you got out and approached him.
Okay, I just played 2 seconds there. You heard an officer speaking to you, correct?
Yes.
And you see yourself listening to the officer.
Yes.
All right, this is a fair and accurate video, or this is a video of what occurred that day of the interview between you and the officer.
Yes.
Okay. I'm going to play this a little bit further here.
Obviously, there's two sides there. My hands were in my pocket like this, okay?
Okay, I've stopped at 15:36. The officer asked you what happened when you got out of the car and approached him, and your response was, I had my hands in my pockets like this. Is that correct?
Okay. Yes.
And at the time you put your hands in, you sort of demonstrated what that was by putting both of your hands into your jacket pockets. Is that right?
Yes.
Now, when the police showed up, you knew that they were conducting an investigation, right?
Yes. Yes. I mean, there was, I think, 3 or 4 police cars that showed up at one time.
And they were interviewing you and they were talking to Mr. Toshak at that time.
Yes.
And you knew they were getting both sides of the story while that was happening.
Yes.
And you knew because the police told you that Mr. Toshak was saying you had committed a crime and road raged him.
The first officer that showed up, I didn't know his name at that point, but the first one that showed up just asked who pulled the gun. He raised his hand. They took him out of the car and handcuffed him right at that point. That was before anyone even came and spoke to me.
But you knew they went back and forth between the two of you several times
Yes.
to ask you different questions, correct?
Yes.
And the police were communicating information to you about what Mr. Toshak was saying the incident had happened during the incident.
I think so. I think, yeah, they might have said that, they asked me if I squealed my tires or locked up my brakes. I said no to both of those.
And I want to ask you about that, so hold on to that thought, that part of the thought for a second.
I don't know that they told me anything directed. I don't know that they ever said, he said you did this.
Right.
Or he's saying you did this. I don't remember that exactly.
But you were generally aware that they were kind of going back and forth trying to sort out the situation as it occurred.
Yes.
Right? Now, regarding the tires squealing and smoking, that is something, that was not your car, right? You did not squeal
No.
or smoke your tires, okay? But that is something that you heard occurring while this incident was going on.
Yes, and I mentioned to one of the officers that said something. I go, well, I know there was a red Mustang on my left at that point. Whether they did it or not, I don't know.
And so just to be clear, your left is still behind the gray car. That Mustang's behind the gray car.
No, the Mustang was in the left lane next to us. It's 2 lanes wide at that point.
Right, but you're directly behind the gray car, right?
Correct,
And the Mustang's to your left,
correct.
so it's kind of like behind and to the left of it.
Oh, yeah, okay, yep.
And that, is that right? I'm just asking where the
Fairly,
Mustang
I
is.
think it is. I don't know if the Mustang was a little farther ahead of me or not. I just know there was, me and a red Mustang had traded places. That's how I got behind the gray car.
And you don't know, I think you mentioned you didn't know Mr. Toshak's name at the time this happened.
I did not,
You never met Mr. Toshak before.
not that I'm aware of.
Okay. You don't have any kind of prior history of any kind of,
No,
no, okay. As far as you know, the same was true for your wife as well.
yes.
I think you said that Mr. Toshak's exact words when he got out of the car is something to the effect, not the exact words, but something to the effect of like, I don't know, you get the fuck back.
Yes,
Okay. And you did that,
yes,
and he didn't pursue you in any way, shape, or form.
he did not.
Okay, he stayed there.
I think he got back in his car when I got into the truck.
And so when after he said get the fuck back and you got back, he stopped pointing the gun at you.
I don't remember exactly when I don't even know if he holstered it. When he got out of the car, it was in his hand. So I don't know if he had a holster in the car for it or whatever, but when he said get back, I got back, got in the truck, called 911.
Okay. And at no point while you were waiting, the car didn't squeal off and leave at that point.
No, we were both stationary. I had my car running and I put it in reverse in case he did get out so I could back up. But once the police arrived, I was in park and waiting.
And other than that statement, he didn't say anything else to you
No,
at that time.
no,
And you didn't say anything else to him other than what you testified to here today.
no.
I have no further questions, Judge.
Thank you. Any redirect, Mr.
I have no
Curry?
redirect, Your Honor.
Thank you. Mr. Foley, thank you for coming in this afternoon. You may step down, sir.
And Judge, I have no further witnesses.
Thank you. Mr. Kearney?
Judge, I would like to introduce a portion of some body worn camera footage that's been disclosed to the defense under the hearsay exception for a statement of that existing mental, physical, or emotional condition or the excited utterance exception. These are the statements that Mr. Toshak made when the police arrived on scene, describing what he perceived to be as a threat that had occurred. If the court sees the video, I think the court will see that Mr. Toshak is describing it. He's still under the effect of that mental state. He's describing that mental state of feeling like he needed to defend himself, but also under the impact of the exciting event that had occurred. Mr. Foley testified that the police arrived within minutes of this happening, and that you can see Mr. Toshak is still agitated and under the influence of that. The point of the excited utterance exception is that when someone's under the influence of that exciting event, that they don't, the gears aren't turning in their mind about how to fabricate a particular statement. So I think both of those would make the statements that Mr. Toshak made admissible under those two hearsay exceptions.
Mr. Curry?
Well, Judge, I don't believe that's what the excited utterance is for. My understanding of the excited utterance exception to the hearsay exclusionary rule is that it's statements made in contemporaneously with that excited event, almost during that excited event. While it happened a few minutes later, it's still Mr. Toshak talking to the police about the exciting event, but it's not statements made during the exciting event. So, Judge, I don't believe that falls under the excited utterance exception.
Anything
I
else?
would say I think Mr. Curry is describing the present sense impression hearsay exception. There's no requirement that the excited utterance exception be made contemporaneously with the event that we're receiving. That's a different hearsay exception. And, it's shortly in time following while we're still under the influence of that thing, that would cause you to make statements that are probably true.
And Judge, may I respond? I may have gotten my verbiage about contemporaneous or causal, whichever word is legally applicable here, Judge, but I still think, even if it was caused by the event, I still think the statements that Mr. Kearney is seeking to admit are sufficiently severed from the actual exciting event that would cause him to speak, in such a manner that were meant to be admitted into this exception, Judge. I'll sit down now.
I'll allow it. Mr. Kearney, do you have it queued up and ready?
I do, Judge.
Are you hooked into the court system?
Would you like me to connect to Zoom, or do you want me to just bring the laptop up there?
So the answer to the question is no, you're not hooked into the court system. We
No, I don't have the
are
HDMI.
fully integrated.
I apologize. If there's an HDMI cable laying there, I'd be happy to do that.
That's fine. Going forward, whenever you have a thing, you can plug in from that table. You just need the cord. We have other cases waiting, which is why I asked.
Oh, I
Was it?
apologize.
No worries. Which is why I asked, were you ready to go? But we will.
No, I have it queued up. I can walk up to, this is plenty loud. The court would be able to hear it.
That's fine.
I'm set on the bench.
Do I need to see him, or is it sufficient that I hear it?
I think maybe
I don't.
seeing will probably aid it. This is just,
He's coming, but you're here, so let's.
all right. Sorry. I know you're trying to get other things.
No, not in a rush.
Okay. Yeah, we both, okay, cool.
Sorry, I apologize.
Wait, who is-
Just for context, this is a passenger in the car.
Oh, I was like,
That's
who
not-
is this?
that's
That's
not
not
Mr.
an
Cheshire.
olive jacket.
This guy fucking intentionally hits me and then approaches the vehicle in an aggressive manner with his hands in his pocket. Neither one is any such fucking. That's just my pocket. Okay, don't move for a second. Don't move, so be cool. We're cool.
Okay. So I don't know if the court heard from Mr. Toshak.
I heard.
Okay.
Okay. Other than that, Mr. Kearney, anything else?
No, Judge. That would be the only thing that I would seek to mention. And for the record, the timestamps that I played were 141 to 158 of Officer McCarthy's body on camera. I'll move to admit that as Exhibit B.
Judge, I have nothing more. Are you asking for a motion?
Argument, yeah.
Could I ask the complainant to be excused?
I'm sorry.
May I ask the complainant to be excused from the courtroom and any potential witnesses for the argument?
Yes, sir. Mr. Foley, you don't have to leave the building, but if you would just step out of the courtroom, I'd appreciate it, sir. Thank you.
And Judge, if you would move for a reminder, I think this is a question of fact, if I've ever seen one, about as to how Mr. Foley approached the car, how what sort of fender bender occurred, how the F-150 hit the gray car. Judge, but I think the testimony we've heard today is that Mr. Foley did approach a car, asked if he wanted to go to a police station, the door opened, a gun was placed, something was said to the effect of, "I don't know you," and despite Mr. Foley's testified demeanor being one of just simply approaching the car, while he did have his hands in his pockets, Judge, I think we have a question of fact here, and if you would move for a bind over.
Mr. Kearney,
Judge, I think that first of all, the question of fact standard is not the standard for binding over a case. Whether or not that's a misquoted case from 1991 People v. Stafford. The Supreme Court made this clear in People v. Anderson, that the court needs to engage with the weight of the evidence that's put before it. And if the court's saying, well, there's a question, I guess we don't have to go through it then, I think that's going to be insufficient. I think the court in the preliminary examination serves a gatekeeping function.
serves
A gatekeeping.
gatekeeping. Thank you.
This court's function is to make sure that the sort of business of the circuit court has cases with a certain strata of evidence that have a certain chance of succeeding at trial and resulting in a conviction is worth, allocating the resources for a jury trial, putting Mr. Toshak through what will be a jeopardy for years at this point. If I had to hazard a guess about how long before somebody's going to get a jury trial in the Third Circuit. And I think looking at this, it is woefully obvious that this case, based on the evidence that's been presented, would fail at trial. That if we were talking about whether or not there was the prosecution had proved that this was not in self-defense beyond a reasonable doubt, this would not succeed. The question becomes, have they shown to a probable cause standard this was not self-defense? You do not need to be actually attacked, in order to act in self-defense. You need to be in honest and reasonable fear for your safety. What we've elicited here from Mr. Foley is a number of things happening. One, he struck the back of Mr. Toshak's vehicle. Two, that they came to a brief stop and then Mr. Toshak continued his turn and then he was followed. And the court needs to analyze this from Mr. Toshak's perspective to see if somebody in that position would have an honest and reasonable fear that someone may be about to hurt them. So the car stopped, gets hit by a car, goes around, pulls. Note that Mr. Foley said that there was a car that he switched places with that was squealing its tires and smoking its tires. Which, if you're in Mr. Toshak's vehicle and you don't know which one it is, you're going to hear a car behind you screeching their tires and then it hits you. You then stop, the car stops, you then pull away, the car follows. You stop again, that man gets out of his car. Doesn't say anything to you. You hear no words from him, and he begins walking up to his vehicle with his hands in his pockets. Now, you'll notice that Mr. Toshak is not charged with carrying a concealed weapon. That there's no basis here because he had a legal gun. We read in the news probably once a week, maybe once a month, about some road rage incident that turns into a shooting on one of the freeways in Metro Detroit. Sitting where Mr. Toshak was, he did exactly what the law entitles him to do, and he did not go further than necessary to effectuate the spell that he perceived the moment to be a threat. He got out of his car, he said, "Get back, I don't know you." And then when, as Mr. Foley said, when he backed up, Mr. Toshak got in his car, you didn't hear who actually were the people. The people didn't introduce the evidence of who all called the police to the scene at the time. And he waited for them to show up. And once they got there, who pointed the gun? Raised his hand. It was me. Because he knew he had done nothing wrong. And what he said to the police was exactly what his state of mind was at that time. The guy was, it was a road rage incident. He was coming at me aggressively. And I had, what did you think I was going to do? He had his hands in his pockets. That is a statement close in time to when this happened, after he volunteered and waited around to talk to the police after this incident happened. Was Mr. Foley trying to attack Mr. Toshak? No, of course not. He's a perfectly nice man. But in the situation that Mr. Toshak was in, with the information he had available to him, he was scared that that's what it's going to be, because that set of circumstances, you could have an honest and reasonable belief that this would be a threat of force. Mr. Toshak inside his vehicle, that's why he gets out of his vehicle, because there's nowhere to go. When they're parked on the left side, there's a passenger in the car with him. And so I would say to the court that it does not have to be the case that whenever there's an altercation between two people and the police get called, that somebody has to go to jail, that charges have to be filed. Both sides could not have done anything wrong. I think that's what this case is. Mr. Foley wasn't doing anything wrong. He was acting in good faith. It's just he had his hands in his pockets. There was a misunderstanding with this red Mustang screeching its tires, leading Mr. Toshak to think they were in a road rage. Mr. Toshak greatly regrets the way this panned out, because at the time he didn't know who Mr. Foley was, didn't know that he was a perfectly nice guy. But in that situation, what Mr. Toshak thought was an honest and reasonable belief. And to bind this case over with this strata of evidence without something else to indicate that Mr. Toshak was acting above and beyond, or that his belief was somehow dishonest or not reasonable in that situation, I think would be a disservice to Mr. Toshak and continuing jeopardy for him for the next several years while he's trying to get a job. None of that really is legal, but I think the standard being what it is for probable cause should be assessed with the consideration of what the effect of finding over a case is for circuit court. So I would ask the court to recognize this for what it is, a misunderstanding that Mr. Toshak is regretful of, and not find this case over circuit court. This is just going to be a titanic circuit court time.
Mr. Curry.
Yes, Judge. First of all, I apologize if my closing, I'm not asking this court to bind this case over. I'm just saying, well, Judge, a lot of things could have been true. This is a question of this, question of that. I'm sorry if that made it seem like it. I should have focused more on Mr. Foley's testimony, which lends itself to what Mr. Kearney's closing argument was, which was the elephant in the room of the self-defense, which, well, I would agree with Mr. Kearney's argument if Mr. Toshak hadn't, or Mr. Toshak hadn't pulled the gun, because while Mr. Kearney is correct that self-defense needs to be in response to an honest belief, it also needs to be proportional. So you can't brandish a weapon and use deadly force in response to someone, I may be hurt, I may be this. So we haven't heard today an obvious, we haven't heard any evidence that while he could have been approaching, Mr. Toshak could have thought he was approaching aggressively. The question of where the Mustang screeching was coming from or how the car was hit, I certainly don't think that rises to the level of an honest and reasonable belief of imminent deadly force. So which would make Mr. Toshak's response disproportionate, which would make it impermissible, which would make it a felonious assault, Judge, and the people would ask for a bind over at this time.
One point I don't think this is not deadly force. Mr. Toshak didn't use deadly force. Pointing a gun at someone is not deadly force. It's just not. If you fire a gun at someone, that's deadly force.
Threat of deadly force, excuse me, Judge.
Do you all want to go out in the hallway and finish talking?
I'm sorry.
The court listened to the testimony of Mr. Foley and reviewed snippets played by Mr. Kearney. Mr. Toshak will be bound over as charged. The next date in this matter will be the arraignment on the information on November 17, 2021 at 9 a.m. at the Frank Murphy Hall of Justice. His previously entered bond with any conditions will continue. Anything else in this matter, Mr. Curry?
No, Judge.
Anything else, Mr. Kearney?
One moment, I'm asking Mr. Toshak. Nothing, Judge.
Thank you. Mr. Toshak, I wish you the best. Have a good day, sir. Ms. Gillis.
Yes, Your Honor.
This is 1S3965984. This is State of Michigan versus Herlane Bates. Appearances, please.
Jane Gillis on behalf of the people.
Good afternoon, Your Honor. Attorney Paul Spagnuolo, P72366, on behalf of Ms. Bates.
This matter was scheduled for a pre-hearing at 3 o'clock today. The court received a note to call the matter at 12:30. You tied up with something else. What are we doing this afternoon in this case?
Your Honor, this was a Zoom hearing on this. I recommend, it's a CDL ticket, so I'm not allowed to make any offers. I recommended to Mr. Spaniel, did I say that right?
You did, Ms. Gillis. That's fine. Spagnuolo.
Spaniel, I advised him of that, and I think that he probably wants to ask for a formal hearing. Oh, wait, is this? Yeah, it's a Zoom hearing. Formal hearing, and we'll just have the officer come in.
That is a correct representation, Your Honor.
I do not have my calendar out to schedule for the formal hearing. Are you able to look it up, or do you? What is?
The last time we were here, I think we were here the last time. I knew it was today. I knew it was November 3rd.
Is the 10th too soon?
The 10th of December or?
Is next Wednesday too soon, sir?
Oh, yeah, Judge, I'm sorry. A couple things. Yes, I'm gonna be in Grand Rapids.
No, sir, no. As soon as your answer to the question is that the 10th is too soon, it will be on December 15th. I just need to get a time for you.
Anytime on December 15th, the Judge and APA Gillis, would everyone be amenable? My client is in Baltimore, Maryland. I can appear in person if the court would like me to, but can my client appear via Zoom, please?
Any objection, Ms. Gillis?
I have no objection to that, Your Honor. That's perfectly fine.
Thank you, Ms. Gillis. Thank you, Your Honor.
Okay, and thank you for zooming in. We really appreciate that.
My pleasure. And I have it December 15th. I have the whole day wide open, okay? So whatever the court assigns me, I'll be available.
Okay, Mary Ann went to go look it up, but what we'll do is, if you want to hold tight for a second, she comes back with a time, I'll give it to you. Otherwise, I have another matter that was scheduled for 1 o'clock. Or do you want to just get your notice in the mail, sir?
I'll wait for my notice in the mail. Thank you so much, Judge.
Oh, wait.
10:30 is your last one, and then I'll examine.
11 o'clock, sir?
Yes, Your Honor. Thank you.
11 o'clock on the 15th.
Thank you. Everyone stay safe.
Thank you. Have a good day, sir.
Bye-bye.
Miss Elijah, thank you.
Good afternoon, Judge.
Good afternoon. There is, this is 20, that's 11 a.m., Ms. Gillis, for that formal hearing. This is 201250, State of Michigan versus Reginald Chambliss. Appearances, please.
I think it might be Mr. Curry.
You think it might be?
Mr. Curry, if he's, I only
He's
have
standing out in the hallway. Hold on one second. Mr. Chambliss, are you with us?
Yes, ma'am.
Thank you. That'd be nice.
Yes, sir.
Chambliss,
Oh, yeah, Chambliss.
Miss Elijah is on. Wait, what? People just walk away. I'm just sitting here doing whatever it is. Was he going to get, oh, he's not even in the room. I'm just randomly screaming out stuff, Marianne. You're jumping on Zoom for what?
I'm gonna hop on Zoom, Judge. From my office.
Why? Wait, what? Oh, we come so close. Is it 2 o'clock ready by chance?
The officers. Wow.
That is not helpful. Did you hear that chair when he sat down? Did you hear that chair when he sat down? I'm gonna bring in a big comfy one. I don't know where Mr. Curry went to log on from. He's lucky we have a break in the action, and I only received something from Miss Elijah, so that's. When you submit the paperwork, that's how you wind up. I get it, I read it, I don't highlight it, but I read it. Silly me, reading stuff. Tomorrow doesn't look bad.
It's tomorrow, Thursday.
Misdemeanors. Misdemeanors.
Week's flying by.
This year is flying by. My husband started talking about putting up Christmas lights.
Oh, yeah, it's good time. I do, if it's nice.
201250, State of Michigan versus Chambliss. Appearances, please.
Alex Curry on behalf of the people, Your Honor.
Emily Elijah on behalf of Mr. Chambliss. My P number is 85039. Mr. Chambliss is connected via telephone. He has he's not very technologically savvy, so he's here via phone today.
No worries, he's been on, he identified himself. We were here back on September 29, 2021. Mr. Chambliss was originally charged with embezzlement, 1,000 to 20,000. The plea was entered with a delayed sentence for 12 months, fines and costs of $500. The matter was scheduled for a hearing on the restitution requested by the alleged victim in this case, or the victim in this case, that being Amazon Inc. This court sent the letter to the probation department to send the letter to Amazon for them to provide the monetary losses that they were seeking in the restitution. That letter was sent on October 6, 2021. As of 3:30 yesterday, this court had not received anything back from Amazon. The court did receive the restitution packet from Ms. Elijah that sets forth an amount of restitution of $398. Mr. Curry, has your office received anything from Amazon contrary to this amount?
Judge, I have Mr. Caldwell on Zoom today, who I was hoping would share the amount that they feel would be appropriate for this restitution.
Mr. Caldwell?
Yes, I'm here. Can you hear me?
I can hear you, sir. Would you turn your video on, please? And Mr. Caldwell, what is your position with Amazon?
He's on mute, Judge.
Oh.
Now,
Mr.
can you hear me?
Caldwell, I am able to hear you. What's your position with Amazon, sir?
I'm a loss prevention manager.
And Mr. Caldwell, what information do you have regarding this incident that occurred on May 26, 2020?
I have a case report where we investigated this case. During the interview with Mr. Chambliss, he admitted to taking 10 AirPods at $199 each. I have a signed statement from him, which I provided to Mr. Curry from Mr. Chambliss, stating that he had taken 10 AirPods and the value of what he had taken was $1,990.
Okay, Mr. Caldwell, this court has not received any of that despite sending a letter asking for some information to support the restitution amount. Mr. Curry, you're going through your files. Do you have a copy of what Mr. Caldwell is referring to?
I believe I do. I do, Judge. Can I bring it into you?
Absolutely. Or you can hand it to, there's somebody in the hallway. I don't know if that's Garcia or Rapp.
It was also attached to the back of my restitution packet, Your Honor.
Something that says, I did not believe that I saw something signed by your client. I thought there was a witness statement regarding it. Is that the same thing that
I'm looking through the packet right now, Judge, just to make sure that.
That's okay.
Okay.
What the court received from Miss Elijah is the theft interview approval template that lists the total estimated value of $398. There are witness notes attached that indicate a different amount where Mr. Chambliss is alleged to have said, I don't remember it being more than 10. But that looks like somebody quoting him, and I didn't take that as a signed statement acknowledging that there were in fact 10 iBuds or whatever, AirPods. It is the same thing. Okay, thank you. It is the same thing, okay. Mr. Caldwell, was there something else?
No.
Mr. Curry, anything else?
Nothing from the people, Judge, just Mr. Caldwell's statements.
Ms. Elijah?
I'll rely on my brief, Your Honor.
Yes, thank you so much. The court is going to enter restitution from Mr. Chambliss to Amazon of $398. That is in addition to the cost assessed when you entered your plea on September 29th. Anything else, Mr. Curry?
Nothing from the people, Judge.
Anything else, Ms. Elijah?
No, Your Honor, thank you.
Thank you.
You
Mr.
can hang up
Caldwell,
now.
thank you for joining us this afternoon.
You're welcome. Thank you.
Thank you, Mr. Caldwell.
Mr. Chambliss, thank you, sir. You can log off now.
You said hang up, ma'am?
Yes, sir. Thank you.
Thank you, Your Honor. Your Honor, hello?
Mr. Chambliss, you can hang up. I'm going to call you later with instructions, okay? But not till later
Okay.
this afternoon.
I'm
Okay,
putting him out. Thank you.
You know that ain't gonna work. Okay.
Thank you, Judge.
Thank you, ma'am. Oop.
Just finished.
I like pulled up here and I've been here for a year, so I feel like that's a traffic ticket. Where is this building?
If you look out in front, there's two spots that I step on because it's popping up in the air. It's like over there and then right here somewhere. Good afternoon.
Good afternoon, Your Honor.
I said, are we ready? And everybody's ready. And you're not really ready. Is that what you're trying to tell me? It's okay. No, you're not ready. I have told him about his interrupting and he just continues to do it. I don't understand.
Because I'm a Spartan, Judge.
Are you done? Because you're a Spartan. Is that what you said?
Because I'm a Spartan. Last one, that's the last one.
I'm a Wolverine.
Thank you.
Alumni too.
Mr. Curry is under the impression that I care and I don't care, contrary to popular belief. 210675 FY, State of Michigan versus William Losell.
Alex Curry on behalf of the people, Your Honor.
Yes, good afternoon, Your Honor. We please design a report, Brandon Bird on behalf of William Losell. Mr. Losell, please state your name for the record.
William Losell.
Thank you. Today is the day and time set for the live exam in this matter. Mr. Curry, are the people ready to proceed?
People are ready, Judge.
Mr. Byrd, are you ready to proceed on behalf of your client?
We'd like to waive this preliminary exam, Your Honor.
Mr. Losell, have you had the opportunity to speak with your attorney regarding your right to have a preliminary examination in this matter? You understand that the prosecutor has to prove that, has to present evidence that shows that there has been a crime that was committed and probable cause to believe that you were involved in the commission of that crime. And after talking to your attorney, you wish to waive your right to have that exam. And that waiver is being given freely and voluntarily. You haven't been threatened in any way, promised anything? I've passed the file down to your attorney to sign the waiver. Once he signs, you'll sign it. It'll come back and the court will sign it. Once the court enters the waiver, the next step in these proceedings is that you'll be bound over for arraignment on the information. That will happen at the Frank Murphy Hall of Justice. I say that that's November 17th, 2021 at 9 a.m., but that's subject to change and your attorney will be in contact with you regarding the date and time if it's different than that. I'm sorry, Mr. Curry, I did not ask you, do you have any objection?
I have no objection, Your Honor.
The court is signing the waiver. Mr. Losell will be bound over as previously charged. Again, the next date in these proceedings will be the arraignment on the information 2 weeks from today. Your previously entered bond with any conditions will continue. Anything else in this matter, Mr. Curry?
No, Judge.
Anything else, Mr. Byrd?
No, Your Honor.
Thank you so much. We are all set in this matter. Good luck to you, sir.
Okay.
We are off the record.
I'm sorry, Your Honor.
Oh, wait, maybe not.
No, I apologize for interrupting you. My client would like to know if there's any way possible we could travel.
any way possible he could travel?
I'm like a purchasing agent for a jewelry store, so I sometimes need to go to Florida.
Sometimes you need to go to Florida from Michigan as we enter into this winter season.
I know it's hard to believe.
Somebody has to make the sacrifice. Any objection, Mr. Curry?
I have an objection, Judge.
Sir, do you have any dates do you propose or just to and from Florida for business?
Just to and from. I don't have any, there's a convention coming up. There's a large trade show that I normally go. And I think that is middle of December, like December 14th, I think. In Tampa. And then in February, maybe France.
I guess maybe France. Is that what you said? Maybe just, the only pause that I have is that once you're bound over, you belong to Wayne Circuit. So I don't know what effect that would have. Me making a note that you may travel for business, I don't know if that will impact one way or the other, but I guess I wrote it in the file. When you get down to Frank Murphy, Mr. Berg can bring it up, and this court has no objection to you traveling, and I don't know if Mary Ann needs to amend the conditions to indicate that he may travel for business. But I'm sending the file that way for her to do, and if there's something else that you need from this court to effectuate that, we can do that. Other than that, Mr. Byrd, anything else?
None at all, Your Honor. Thank you.
Thank you. We are all set now, Mary Ann, and off the record. Thank you very